My name's Alex Dolphin, and welcome back to another episode of Ex Ante. Today we're going to discuss the case United States v. Microsoft Corp. This case was heard in the D.C. Circuit Court of Appeals in the year 2001. Let's go ahead and jump into the facts of the case. So this case was brought by the United States of America and several other states against Microsoft for violations of the Sherman Antitrust Act. So the Sherman Antitrust Act, if you're not familiar with it, is an act that was passed in the late 1800s, and basically what it does is it prohibits any contract in restraint of trade or any type of monopolization of a market. So this is the key antitrust law. And antitrust, what it seeks to do is prohibit people from working in concert with one another to suppress competition, right? And in essence, ultimately harm consumers. A free market capitalist system depends upon competition. If there's not competition, right, if there's illegal arrangements, or if there's a company with so much power that it has a monopoly and no one can compete with it, well, then that's bad for the consumer, right? That anti-competitive behavior is bad for the consumer, and that's what Congress sought to eliminate when it passed the Sherman Antitrust Act. And so this is an action brought by the United States and other states against Microsoft saying, hey, you violated this. And so the facts giving rise to that are somewhat interesting. So this case was brought right when Microsoft was coming out with Windows 98. And the case was brought a few years earlier. And basically what they alleged is that Microsoft was bundling Internet Explorer and the operating system and the Microsoft Windows operating system. So those two were bundled. As soon as Internet Explorers began to come about, which Microsoft didn't come out with the first Internet Explorer, Microsoft saw, hey, well, this is going to be a huge thing. Web browsers are going to be necessary, in the growth of the computer system. And so we're going to come out with our own web browser, and we're going to call that Internet Explorer, as I'm sure many of you are familiar with. So what they did, though, when they were doing that, was they made it so no one could uninstall Internet Explorer off of any Windows machine, and it just came right on the Windows machine, right? So you're always going to get this Internet Explorer that you can't install, and you're probably going to use. Well, there's other companies that were coming out with web browsers. The one that the court discussed most deeply is Netscape. So Netscape came out with the Netscape Navigator. And when Netscape was trying to develop this web browser, they went to Microsoft because they needed some key information, some key technological information to develop this browser to get it to work with Windows. And Microsoft was very shady. They did not want to license that information for obvious reasons, right? They knew they were going to be in the browser market, and they knew that if Netscape got into it, they're going to have some competition. So they were very slow to give any of that information. And ultimately, they didn't give Netscape the information that was necessary until 3 months after the holiday season, after Windows launched, or after Microsoft launched Windows 98, right? So, well, the argument is, hey, you can't bundle Internet Explorer. You can't make it so you can't uninstall it off of Windows operating systems, and you need to make it so that there's some competition in the browser systems. And if there's no competition in the browser systems, the consumers are going to be harmed. So the district court ultimately did a lengthy trial where it issued some findings of fact. It was a bench trial. And after it issued the findings of fact, it said, hey, Microsoft and the plaintiffs, why don't you guys go to arbitration and figure this out? And they're like, okay, we'll do that. They go to this arbitration, this mediation, and Judge Posner, a very famous judge, presides over that. Well, they work for many days. Ultimately, they can't come to an agreement. So they go back to the district court. The district court, says, okay, well, you want my conclusions of law? Here they are. Microsoft, you violated Section 1 of the Sherman Act and Section 2 of the Sherman Act. So Microsoft is, obviously they got money and they're going to appeal this. So they appeal it to the D.C. Circuit Court of Appeals. D.C. Circuit says, hey, I think, the Supreme Court should look at this. This is pretty intense. The Supreme Court says, no, D.C. Circuit, you deal with it. So D.C. Circuit deals with it, and that's the opinion that we're discussing here. Ultimately, the D.C. Circuit Court of Appeals, sitting en banc, just said, yeah, we find some merit in a few of Microsoft's arguments. They didn't flat out violate both of these sections as clearly as the district court thought they did. First, the court talks about monopolization. So monopolization is prohibited by Section 2 of the Sherman Act. And the court says, there's two elements to the offense of monopolization. First, the possession of monopoly power in the relevant market, and then two, the willful acquisition or maintenance of that power is distinguished from growth or development as a consequence of a superior product, business acumen, or historic accident. The Supreme Court has also defined monopoly power as the power to control prices or to exclude competition. And ultimately, the D.C. Circuit Court of Appeals agrees with the district court and says, yeah, Microsoft, they have monopoly power here. They describe how Intel processing machines, really the only operating system that can work off of that is Windows. And they're the only machines that are affordable for people to buy. The only machines that are affordable is personal computers and small businesses, things like that. And so they do, in essence, have monopoly power. And so they say, yeah, Microsoft, you violated Section 2 of the Sherman Act when you began to engage in anti-competitive conduct with this monopoly power. And that anti-competitive conduct was, the process of basically boxing out Netscape Navigator and not letting other web browsers kind of use the information that Windows had to try and develop a competitive product. So violation of Section 2, yes. Now, there's also, the plaintiffs bring a violation of Section 2 for an attempted monopolization of the web browser market. Now, the court doesn't really like this. The D.C. Circuit Court of Appeals says, yeah, we're going to, this is not good, okay? You have to provide a whole different type of analysis if you're going to do attempted monopolization. This is not the type of analysis that the district court did. So, sorry, maybe there's a chance, but you didn't do the correct legal analysis, so we're going to reverse that. Now, the last portion of the opinion that I'm going to talk about is tying. So the plaintiffs also alleged a violation of Section 1 of the Sherman Act, which prohibits any illegal contract or combination in restraint of trade for tying. Now, what's tying, right? Tying is when you bundle two products together and you can't get one without the other. And that's in essence what happened when when Microsoft shipped Windows with Internet Explorer, and you really couldn't get one without the other, right? You can't uninstall Internet Explorer. So tying normally is a per se violation of the Sherman Act. And what per se means is the courts aren't going to look at any evidence. If there's if there's evidence of tying, then that's a violation of Section 1. Now the court says, well, software, this is a new industry that we don't really know much about. So at least in tying with software agreements, we're going to subject that to a rule of reason analysis, which is a much more deferential, right? Like there's still a chance that you're going to be found to violate Section 1, but it's not going to be just cut and dry. Looking into the rule of reason says it involves an inquiry into the actual effect of Microsoft's conduct on competition. So that's going to be a very heavily fact-based analysis. How much of the market do they have? How much did this really impact the browser market when they tied these two things together? So I guess one more note before we finish with the opinion is kind of interesting. The court, so the district court judge actually conducted some interviews with the press, with the Washington Post, the Wall Street Journal, a lot of other big press outlets, and was talking about how Microsoft was this big bad person, and here I am, I'm going to smack them down. And the D.C. Circuit Court of Appeals says that was really bad, district court judge. You absolutely should not have been talking to the press while this opinion was going on, or even afterwards. That is a violation of the Judicial Code of Conduct. But they ultimately say, that doesn't mean we're going to reverse the whole district court's opinion. We looked at it. It's basically harmless. We've looked at the facts, we've looked at the analysis ourselves, and we're not going to say this all goes away like you would like Microsoft. So thanks so much for watching. Hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button, and I hope you have a nice rest of your day. Bye-bye.